Good afternoon and welcome to today's presentation, Insurance Agents and Brokers, Standard of Care. In today's webinar, Mr. Cohen will discuss the basis of E&O claims, the difference between an agent and broker, how to identify the relationships between the agent and/or broker and the insured, the features and potential duties that an agent or broker may owe to an insured based on the type of relationship and specific circumstances that formulate the standard of care. To give you a little background about our presenter, Ivan Cohen, he has 38 years of experience as an insurance agent and broker. He is the president of the Cohen-Putnam Agency. Mr. Cohen was a senior adjunct professor of insurance for 13 years at Westchester Community College. He is currently a subject matter expert for the New York State Department of Financial Services and is on the Insurance Exam Review Committee. Attendees who require a passcode, the word for today is CARE. During the Q&A session, we will ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you're applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Tomorrow morning, we will send out an email with a link to the archive recording of the webinar. The slides can be downloaded from the resource list to the left of your screen. Thank you all for attending today, and Ivan, the presentation is now turned over to you.
Well, thank you very much. Welcome to all. I would say good morning, but I know we're at different parts of the country, so welcome. Today's presentation on the agent and broker standard of care. First, I want to qualify the fact that the content of this is for informational purposes, and I am neither on the defendant or plaintiff side in this presentation. And as a matter of record, I actually do work on both plaintiff and defendant sides, so I'm going to try to be as neutral. But I am going to share with you points as they come up, which may favor one side or the other, but we'll try to keep it balanced because it is important for you to understand that certain things can slant one way or the other, and I'm going to show you a few areas of concern as we get to them. As we talked about in the objectives, as Emily presented earlier, we're going to break it down into several sections. We're going to talk about the basis of E&O claims. Understanding the genesis of what creates it is critical to understanding the standard of care because there are a lot of things that the insurance agent or broker may be expected to do or is expected to provide to the insured. And that's not always going to be the case. The genesis of the E&O claim is going to show you that there's really opposite ends between when the insured seeks the insurance and when the claim is denied or not sufficiently paid. We'll distinguish between an agent and a broker. A lot of times these are used interchangeably. There are some key distinctions between these two, and they can be, again, critical to determining what responsibilities the insurance agent or broker would have. The relationships between the agent and broker, we'll be discussing the law of agency and insurance law, and how those two actually operate simultaneously, rather unique to the insurance industry. And the features and potential duties that an agent or broker may owe to an insured based on the type of relationship. And here we're going to discuss there are actually three relationships: common law duty, the special relationship, and the fiduciary duty. And we'll address those as we go along. Dealing with one fact, the standard of care in an E&O claim, the standard of care is really a mixed question of law and fact. A lot of it is based on common law, and it is incredibly fact-specific. Part of the problem is the fact that you have two sides who aren't seeing the same thing, and part of that problem is the fact that insurance has a unique set of language, and that creates a problem in terms of what the fact pattern actually is. The fact finder is going to be asked to determine what the insured is entitled to expect. This is also going to be state-specific, and certain states have certain levels of advisement. Many of them, by the way, do not have a high level of requirement for advisement. The states are going to frame the case, again, on fact-specific. And I want to emphasize that the conflict between the law of agency and insurance law exists. We're going to talk about situations where we'll have duality issues, but actually in the insurance arena, you can actually have where the insurance intermediary, the agent or broker, is actually representing both sides in the transaction, and yet in many cases it won't actually be a conflict of interest. But these are issues that do come up in the lawsuits, and it could be favorable, depending upon how it's played, it could be favorable to the plaintiff or the defense. Now, getting into the anatomy of an E&O claim, there's three components, well, there's more than three components, but initially, the insurance is purchased by the insured, and it really is a speculative purchase. It's trying to be on the proactive side of things, saying, I believe that there is, that I'm concerned about something happening, there's a financial exposure here, and I want to transfer this to the insurance company. The problem when we get to this part of the E&O claim is that in many cases, the insured is not very specific in what they really want in the way of insurance. And they'll come in very often and they'll use terms like adequate, proper, full, complete, generic terms which really don't give an insurance professional a lot of clear understanding. As you'll see, this becomes important when you look at the common law duty. The obligation is on the insured to specifically request coverage. So right from the beginning, when we look at the E&O claim, there's usually a communication problem because the insured is not specifically requesting something. They're not quite sure what they may need, and then the insurance is procured. Then we go through and a claim occurs. Now, a claim occurs, it's filed with the insurance company. The insurance company is now going to be looking on the back end. Now they're going to take the actual fact pattern of exactly what happened, and they're going to overlay that onto their insurance policy to see whether or not what happened fits the coverages in their insurance policy. Included in that, which an insurance agent will never, or a broker will never know, is what the actual intent of the insurance company is with respect to how they want to pay the claim. So there's a lot of details that are going to come on the back end in analyzing whether the claim is going to be paid and under what terms or conditions, as opposed to at the front end when the purchase is being made. This is also important to recognize that when the insurance purchase is made and the obligation is trying to be imposed on the agent or broker saying you have a responsibility to explain the coverages, make sure that they're properly covered, this can be a difficult issue because in reality, you don't know how the insurance company is going to respond. You don't know what their intent is at the time of the claim. You don't have an actual fact pattern to work with. So working with hypotheticals on the front end at the time of purchase and then the actual fact pattern being applied by the insurance company on the back end, that too becomes an issue that comes up in E&O claims as to how can you possibly cover everything. And again, when the lawsuits come in, everybody is suing for a number of different reasons, but this is where the big problem comes in at the front end on the purchase and then the way the insurance company is going to interpret it. Once the insurance company makes their determination, and recognize that the agent or broker generally does not have any control over that. Once the claim has gone in, the insurance company is going to make the call on that. And the insurance agent or broker may be able to give it a little bit of a push, but generally not much. And so if there's a deficiency or an insufficiency in the claim payment, generally that begins the E&O claim, and problem starts. Now, we want to qualify some insurance terminology in terms of the label that we're going to put on, because we're going to use the term agent, we're going to use the term broker. There is a distinction to them. How important the distinction is depends on the context in which it's being used. So for all purposes, an insurance intermediary is the overall overarching term that would take into account a broker, an agent, or a producer. Now those terms, again, do have certain other meanings, as we'll see in a minute. Generally, from a regulatory standpoint, it's usually not significant. Some states, for example, Jersey, only issues a producer license. Yet, inside of their regulations and their statutes, they do make reference to agents and brokers, and the standards can be a bit different. Not necessarily in Jersey, I'll qualify that, but in other states, sometimes they'll view an agent and a broker as being different. Some states view them both as the same, so whether you're an agent, you're a broker, or you're a producer, you're the same thing. So the label doesn't necessarily mean anything in certain states. Now, when you're trying to qualify whether somebody is an agent or a broker, it's going to be critical to determine what state is going to have application, what law is going to apply, what state law. If you have policies that are written in one state, the broker is in one, or agent is in one state, the insured's in another state, it might be tied to some third-party accident in another state. As an example, I have a case that I'm working on now was related to an automobile accident. The accident occurred in Jersey. The insured and the insurance broker are New York. Yet the case was filed in New Jersey because it came off of an auto accident, so there were some third-party beneficiaries involved. And so now the state law of Jersey is going to dictate, even though as part of the E&O claim, both of those parties are New York-based. And again, the type of agency is going to be important, and we're going to talk about that in a little bit more detail going on, but you have different categories of how people do business, going from someone who's completely controlled by the insurance company to someone who may represent the insurance company to someone who's completely independent, representing the insurance company but completely independent. And then you also have those who are brokers, which have no direct representation of an insurance company. And again, different obligations can apply to each of those. Now, when you're talking about the agent, authority can become an important factor. If you're acting as an agent of an insurance company, the actual appointment is going to be filed with the given state. So where an insurance agent is representing Company X will file a form with the respective state that the agent is operating in, saying that this is an agent of ours in this state. There will be a contract between the insurer and the agency. This becomes very important because depending upon the terms of that contract, there are going to be obligations, which we're going to discuss in a minute, that the agency is going to have to meet contractually, and that can in certain instances, create a problem with the relationship that the insurance intermediary or agent will have with the insured. There are certain authorities that are given as an acid test, if you will, to determine whether someone is actually an agent of an insurance company. And the easy question is, do you have authority to bind the insurance company? If you're acting as an unauthorized agent of an insurance company, they have given you certain authority. One of them, the most critical one, is going to be the power to obligate them and bind them on insurance coverage. If an agent or a broker says to you, I don't have binding authority, then they're not an agent of the company. The primary
Ivan,
is to, yes.
Could you possibly speak up a little bit? Some of the attendees are having trouble hearing you.
All right. Is this better?
A little bit, yes. Thank you.
Is that better? Yes?
Yes.
I'm sorry if you couldn't hear me.
Okay, thank you.
All righty. We're on page 16 for those of you who couldn't hear me before. The primary duty, when we're talking about insurance agents in general, the primary duty is to represent the insurance company. Now, bearing in mind this is based on a contractual relationship between the agency and the insurance company. So the instructions that are going to be dictated by the operating instructions from the insurance company, their guidelines, and all the rules and regulations that they impose are going to have to be adhered to by the insurance agent. And again, I want to emphasize that when they're operating in that environment under a contractual obligation, it does put them in a position where they're at odds to a certain extent with their representation or how they will handle the insured, because they've got a contractual obligation with the insurance company. They may, in fact, not have any express contract with the insured. There might be an implied contract, but quite often there really isn't any contract of any substance in place with the insured. So what's going to dictate in a lot of cases is going to be what are their legal obligations contractually to the insurance company. And one of the other obligations, and this is where the fiduciary issue comes in as far as representing an insurance company, is that an insurance agent must account for all funds. They must transmit all funds to the insurance carrier, and they're acting in that capacity as a fiduciary, in a fiduciary capacity with the insurance company. what you'll see as we go more towards the end of this presentation is that the fiduciary duty that one might think that an insurance agent or broker would have to the insured really isn't there. There are some qualities of a fiduciary capacity, but as you'll see at the end, they're really not. There is really no fiduciary duty in most instances that have been found by the courts. The basis of the insurance agent's duties is really responsibility to the insurance company. So to put it more simply, if there's a choice between following a contractual legal obligation to the insurance company or to the insured, the insurance agents or brokers most likely are going to legally have to face the insurance company and favor them. And that, again, does present a problem with trying to have dual loyalties. All right, now when we talk about the independent insurance agent, and the critical word here is independent. What distinguishes an independent insurance agent from a regular agent is that the independent insurance agent will generally represent multiple companies. That gives them the degree of independence. So as someone who's an agent for an insurance company, just an agent for an insurance company will most likely just represent one insurance company and bound to contract. When you become an independent agent, you have access to multiple companies where you have contracts with them. This is an important point for consideration because insurance companies, when they're dealing with independent insurance agents, will quite often try to raise a defense if they get pleaded into the lawsuit or named in the lawsuit. They will sometimes raise a defense that because it was an independent insurance agent, even though we have a contractual arrangement with them and we've granted them certain authority, they in fact weren't obligated to place that business with us. They could have gone to many other carriers. They selected us and we gave them certain authorities, but they're really not captive to us, and therefore we shouldn't be responsible for all of their actions. Sometimes they'll raise that defense, and sometimes it works, and sometimes it doesn't. So it's important to recognize that when you see someone who's an independent insurance agent, they're going to have multiple carriers, and you might see that come up as a defense from an insurance company. And as you can see, the duality starts to come into play here because there is a degree of duty to the carrier and there is a degree of duty to the insured. And again, exactly what those duties are going to be depends on the relationship that's created. Most of the duty under a contractual obligation to the insurance company is going to go to the insurance company. The duty to the insured when you're operating as an independent insurance agent is mostly going to be to collect the insurance premiums and transmit them to the insurance company. That is usually where the duty will come into play as an independent insurance agent, barring, and I'm going to qualify this, barring the creation of a special relationship. So in many cases, the common law duty, which I will jump a little bit ahead, the common law duty is really very simple. Procure the specifically requested coverage using diligence, reasonable skill, care, and diligence, or advise the insured in a timely manner if you can't do that. And fiduciary capacity is to collect the premiums and remit them to the insurance company. So the issue of the relationships when you're an independent insurance agent still skew towards the insurance company because of the contractual relationship. There is some degree of duty to the insured, but most of it's either common law duty in most states and just the transmission of the premiums to the insurance company when an insured makes a payment to you. Now, generally, as I indicated earlier, the duality, the general law of agency versus insurance law, generally doesn't work very well. In this case, one of the big issues is who's the principal and who's the agent. And when you're talking about being an agent under the insurance law, as I indicated earlier, the agent will represent the insurance company, the principal being the insurance company. If you're acting as a broker, and we're going to address that shortly, when you're acting as a broker, then your principal is really the insured, and you're an agent, and you're going out to the third parties representing the insured, and the insurance companies being the third parties. So depending upon whether you're acting as an agent or a broker will determine who the principal is, and you're always the agent. The insurance intermediary is always going to be the agent under agency law. But under insurance law, if they're representing the insurance company, that would be their principal. If they're representing the insured as a broker, that's when they would be the principal. Okay, now we have some terms that, and I mentioned these earlier, but I want to qualify them. The captive insurance agent. Captive insurance agent represents only a single carrier. And the fact that they're captive, for example, would be Nationwide, State Farm, and Allstate. They represent one carrier. They're under contract to that carrier. And that's the extent of their insurance relationship. So they may be an employee. In some cases, they're operating not as an employee, but they're captive to that insurance company that they can't represent contractually anybody else, as opposed to an independent that could represent many different companies. Direct writing agent is actually an employee of the insurance company. A good example of that would be Geico. Geico, you call an 800 number, and you get a representative there, and they're going to handle the transaction for you, and they are actually an employee of Geico. Why is this important? Well, as you'll see, the obligations, so in a little bit you're going to see where the obligations, if you're an employee of the insurance company, you may not be able to get access to that person that you were speaking with on the phone. So you'd have to sue Geico, and the actions of the representative that was on the phone, they will not be impleaded into the case because they're an employee. So then you get caught up in the respondeat superior situation, and it's a much tougher case to handle. When we get to brokers, there's no authority to bind. And again, I said, as I indicated earlier, this is one of the distinguishing factors. If you're trying to determine were they acting as an agent or were they acting as a broker in the particular situation, the key question would be, did they have any authority to bind coverage on behalf of the insurance company? Was that granted to them? As a broker, you have no authority. Everything basically has to be approved before anything happens. So you have to have prior authorization submit the application, get prior authorization from the insurer. You would have to have the insurance company execute the binder and issue everything, and you're basically an intermediary between the company and the insured. But when you're acting as a broker, your principal will be the insured. So the question would be, well, if the insured is my principal, don't I have a higher standard of care? Don't I have a greater obligation or a heightened duty? And the answer is maybe. It all depends on what was said in the course of the transaction, and we're going to break that down in a little bit. We actually did cover 21. All right, now on securing and placing an order with a company selected, one of the other things is who selected the insurance carrier. In some instances, a presentation may be made with multiple carriers. The insured says, I want to go with carrier B. In other cases, the insurance broker may suggest to them and present to them and say, this is the best of the quotes that I've gotten. This may be the only quote that I've gotten. So in some cases, the broker has selected the insurance company, or the insured has selected if there were multiple companies. Does that make a difference? It might make a difference, but in a lot of cases, it really won't. Okay, determining whether it's an agent or a broker, I want to emphasize that in certain states, whether you're an agent or a broker does not make a difference. So the label of what your label is really isn't critical. And I would suggest that you look at the fact of it's not what you label them, but it's what they say and what they do. So really, what you need to do is follow the fact pattern, and you have to go through the entire transaction in order to establish exactly what capacity the insurance intermediary was acting in. Now, one of the other problems that's created by this agent-broker situation is the fact that you can have an independent agent actually acting as both an agent and a broker. This is a very common situation where they may have contracts with an insurance company where they do, in fact, have binding authority. They're the agent of the insurance company, and they're handling insurance for this insured. but they have another policy for this insured where they've had to go out to the marketplace with no authority, effectively acting as a broker, and place that insurance on behalf of the same insured. So you can have multiple policies for an insured, some of which have been placed as an insurance agent, and some of them have been placed as the insurance broker. The insured generally has no idea in what capacity the insurance intermediary is functioning. As far as they know, this person is representing them, and that also becomes part of the problem until a lawsuit comes up, and then you have to distinguish in what capacity were they working, and what was some of the obligations they might have had to meet. Moving on to 24, we have some questions. Oh.
Could all the attendees please type the passcode into the Q&A? Our first question is, how important is it to determine whether the insurance intermediary was acting as an agent or broker?
Well, it's quite important, in my opinion. Now, again, in some states, it's irrelevant in terms of the labeling, but what's really going to be important is how the transaction flowed. So understanding in what capacity they were working. To reiterate, acting as a broker, from the law of agency, if you will, acting as a broker, generally the principal is going to be your insured. And that means that you're representing them to the insurance companies. So looking at it from that perspective, your loyalty, if you will, your obligation is to the insured, as opposed to an agent where you have a contractual obligation to the insurance company. And when push comes to shove, if you're an agent, you're going to have the conflict of, do I lean towards the insured, or do I lean towards my legal obligation contractually to the insurance company? And that's where some of the problems come in for an insurance agent. So it's really critical to understand the role that they were playing. Also, it's important to know the role that they were playing, because if they were acting as an agent for the insurance company, you might have access to the insurance company that they were representing, and you might be able to bring them into the lawsuit. And again, I want to emphasize that if it's an independent agent, the insurance company may raise the defense that because you had access to multiple different insurance companies and not just us, that really we shouldn't be obligated for the actions of the agent. So it is an important characteristic to understand what the operation was. Just to qualify it further, most insureds will always think that the insurance intermediary is representing them, is their insurance agent, when technically that may not be the case.
Okay, what is the difference between an insurance agent and a life insurance counselor?
Well, again, there's a couple of different words there. Let's take the back part first. A life insurance counselor, when you bring in the word counselor, that becomes an advisory term. So someone who is going to be counseling in any way is really being engaged for advisory purposes. Whether or not they have the ability to sell a product is something that would have to be disclosed. When you're talking about an insurance agent, you could have an insurance agent that deals with property and casualty insurance. You could have an insurance agent that deals with life insurance or disability insurance. And again, the word being agent usually is going to indicate that they're representing an insurance company or multiple insurance companies. So those are two different roles, actually.
When a broker or independent agent inherits a policy from another broker or agent, what is the duty of the agent to evaluate the coverage to determine whether it is sufficient and it is optimum for the client?
Okay, that's a very loaded question. So let me break that down. I'm not sure when they say inherited it. So I'll go on the basis when they've acquired it in some way. Sometimes they could have bought a book of business. Sometimes it could be they've taken it over on a broker of record letter, but it's come from one agency to the other agency. So once the new agency gets it, they technically are responsible and they have ownership of everything related to that. As far as their obligation to review the policy, there's a couple of problems with that. But first of all, when you take over a policy from somebody else, you really do not know as the new agent what was said to the insurance company when that policy was originally applied for. And that could become a problem because there could be defects in the application when it was originally written that could come back and compromise a claim that the new agent would now become responsible for. And they have no knowledge. So one of the things in taking over a new policy, it's usually a good idea to literally rewrite the whole account. You can stay with the same company, but write a whole new application, and that way you know what's going into the insurance company. The downside with that is that you may find that the insurance company, based on the new information, might not want to write that account or write it the same way that they did. But that would be the prudent way to handle that. As far as the obligation to advise them as to the adequacy of the coverage, that's where you start getting into the semantics of the words. Insurance agents and brokers, normally under the standard of care, are not responsible for picking values, for talking about adequacy, and we're going to get into that in the second half. So they don't really have an obligation to necessarily review the coverages to tell you if they're sufficient or adequate or proper. If they choose to do that, they can, but there's no legal obligation to do that. So I hope I've answered the question there.
Okay, the next question is, all these requests for insurance and transactions between insured and broker/agent are verbal. What level of proof is needed to determine if the relationship turned into a fiduciary one or where a certain type of insurance was requested but not provided?
Okay. Well, again, as attorneys, you certainly know that anything that's verbal is difficult. The he said or he said, she said, he said type of situation is going to be difficult. My experience in the cases that I've worked on that the paper trail really dictates. Most often, anything that's been done verbally is usually a mess anyway. And again, I want to emphasize this because there's a communication gap. In words that are used in insurance, in certain insurance terminology, which also has, common layperson definitions, but they can mean different things. As an example, someone might use the term all risk, which is something we try to avoid doing, but people will use that term, either insureds or insurance intermediaries will use the term all risk. Well, that, of course, it gives the impression that everything is going to be covered, and that's usually not the case at all. There really isn't any all-risk policy out there. There's always some exclusions, and all you need is one exclusion. It's no longer all risk. Terms like comprehensive or other terms that have dual meanings, and the layperson is going to see it from their perspective, but it has really, in the insurance world, a completely different meaning. So the verbal aspect of it becomes very difficult. It's really going to get down to following the creating a transactional map, if you will, and you're going to have to start with the initial meetings and then follow the paper trail and the progression of exactly what happened to try to formulate what was agreed to, what wasn't agreed to. And I want to emphasize, as we're going to get into it in a minute, you're going to find that any defects in terms of where an E&O claim is going to be presented are either going to be procedural or knowledge-based. And so what you really are looking for when you're going through all these things is, did the insurance intermediary, what they did that might have caused, or what's being alleged that they did, was that related to something that was knowledge-based, or did they mess up procedurally? And there should be a transactional pattern that you can follow, and that will help you do that. But the verbal always becomes a big problem.
Okay, those are all the questions we have for now, so please continue with the presentation.
All righty. All right, we're on page 26, slide 26. Now, the basis of the lawsuit, and in E&O type claims, I've seen 5 different bases that or theories that can be imposed into the lawsuit. We're going to focus on the common law negligence because that's the one that's the baseline that we see, obviously in every lawsuit. Whether or not there's a breach of contract, you start getting into the issues of, was there an express contract or was it an implied contract? In most cases, there will not be an express contract between the insurance agent or broker and the insured. However, if there is a contract, a written contract between those parties, that actually can help the insured in certain instances if the agent or broker didn't live up to the terms of that, and we'll talk about that when we get to the special relationship. Fraud and misrepresentation, again, are going to be very fact-specific. I've seen many cases where they'll put an allegation of misrepresentation in there, that the agent or broker misrepresented something to the insured. And this also becomes a problem because the question is, what did they misrepresent? Did they say words and say phrases and terminology that the insured misinterpreted? So the agent or broker might not have misinterpreted it. The insured might have heard it, processed it through their use of those words, and come out with a different finding. Although I'm not going to say that agents and brokers don't misinterpret. That's not the point. It's just usually it's a communication issue. Again, also misrepresentation could be created by lack of knowledge on the part of the an agent or broker. Breach of fiduciary duty comes in often because everybody thinks that the agent or broker is in a position of trust. However, and I address this at the end of this presentation, the reality is that most courts, based on cases that I've reviewed, don't find that there's a fiduciary duty in its truest sense. So we'll talk about that at the end. But focusing on the common law negligence, okay, as we know, there's the four parts: the duty, the breach, the proximate cause, and the damages. The duty is the anchor of this whole thing. If you don't qualify the duty, nothing else here is going to work. And of course, that's what the purpose of this presentation is. What were the obligations and the duties that the insurance intermediary, agent, broker, producer, what were they supposed to do? And then did they breach that? Getting to that duty is the difficult part. Now, establishing the duty here, in one way, of course, we're going to look at accountability. So we're going to say, what was this insurance agent responsible for doing? And I want to emphasize that in these cases, the insured has the burden of proof. So in this case, the plaintiff has the burden of proof of having to show that there was some agreement to render services beyond the coverage requested. And this becomes a fine line. There are a lot of cases, there are cases that I've worked on and am working on, where there was no specific request for coverage. There was a general term: I want complete coverage, I want proper coverage. In a lot of other cases, there's issues that come up about premiums and pricing, and I would suggest that don't discount that when that comes up, because it does put insurance people in an awkward position. If someone comes in and says, I want to save money, I want to be covered completely, but I need to save money. Well, those are conflicting obligations, and what ends up happening is the insurance agent or broker may make some calls, judgment calls, on what they think they want, and that becomes another issue that has to be, again, qualified and very fact-specific. Now, getting into what the fact finder is going to be looking for, they're going to look at the nature and the content of the discussions between the agent and the client and the prior dealings of the parties. So one of the issues is going to be, in most cases, people think that, well, if I've had a long-term relationship with this agency, then I have a special relationship with them. I have a unique relationship with them, which may be the case. But generally, the length of time that you've been with an insurance agency by itself is not going to elevate. The courts may not find that really gives you a heightened duty as an insurance intermediary just because you've had a long-term relationship. Usually there's a lot of other things that are going to be looked at by the court. Knowledge and sophistication of the client. Obviously, if the client is more sophisticated, they should be able to grab the theory being that they should be able to understand certain concepts and certain terminology and have a better understanding of what they want to have in the way of insurance, as opposed to someone who's maybe not as knowledgeable or sophisticated, and they may be at a disadvantage. Whether the agent holds himself out as an insurance specialist, consultant, or counselor, and those are important terms. If someone holds himself out as an insurance specialist, and I'm going to emphasize not specializing in insurance, but in specializing in certain types of insurance. We specialize in restaurants. We specialize in trucking. What they've done once they start to qualify what they specialize in, they have actually moved themselves, potentially moved themselves into a heightened duty, because it's going to be assumed by the insured that they have this expertise in this particular field, and they'll go to them relying on the fact that they've held themselves out as having expertise in a certain field, as opposed to a lot of agencies who are pretty much generalists, and they'll handle a little bit of everything. They don't really specialize and have specific knowledge in any particular industry. So that would be important. And again, when you get into the terms consultant or counselor, now you're holding yourself out in an advisory capacity. And now again, could that be interpreted as, well, you come to us and we're going to give you advice in addition to placing the insurance. So those terms, if they hold themselves out like that, could create a heightened duty. Whether the agent receives compensation for additional or specialized services. This is another critical thing. If there is an agreement where the insurance intermediary has said, I will provide certain other services to you for X fee, whether that's in writing or whether it's verbal but the money has been paid, if there's additional compensation there, then that again is one of the criteria that will elevate to the heightened duty. The standard commissions that an insurance agent or broker would receive is not considered the compensation to raise the duty. Okay, so what we look at here is the failure to use the degree of skilled care that a reasonably prudent person engaged in the insurance business would use under similar circumstances. So when we're looking at the negligence here, when we're looking at the carelessness here, we're going to look at the standards that a prudent person engaged in the insurance business would use under similar circumstances. And as attorneys, you certainly know there's a lot of generalization in there. So basically, you're going to look at, there are different ways that things can be done in the insurance business. And two agencies could be going for the same thing in terms of placing the insurance, but their processes to get there and how they approach it could be substantially different. But there are certain fundamental things that need to be followed. The question is, did the person go far out of bounds from what the standards would be? And those standards can be imposed by the geographic area, because there are some things that are different around the country, but a lot of it is also imposed by statute or, in many cases, the regulation of the given state. Okay, now the last sentence on this I want to qualify because I think it's really important. It can be doing something that a reasonably careful insurance agent or broker would have either done or not done. And it's the not done that I want to emphasize. So quite often we're looking and we're going, well, they didn't do this. But the question is, did they do something that they shouldn't have done? Did they overstep their bounds? Did they do something that compromised the coverage? For example, maybe they misrepresented something on the application. They didn't ask the insured, and they took the liberty of marking something off that they thought was an innocuous, non-important piece of information, and yet it turns out that that very action is what might have caused a problem on the claim. That's not something you normally would do. So that would be a basis for a problem. So when we look at the legal duties versus the standard of care, the legal duties, of course, come from the state laws. They're contractual obligations that are dictated by contract arrangement with the insurance company, and then we're going to be operating under the common law duties owed to the insured. And the common law duties are really a very low bar. And we're going to get to that in 1 minute. But here's the three relationships. You have the common law duty, which, by the way, the vast majority of the states adhere to the common law duty as the starting point. Then you would elevate up to the special relationship or special circumstance. The criteria to get to that are some of the things that we talked about in terms of additional compensation, how you represented yourself in terms of having expertise in a particular specialty, length of time. These are all characteristics that could lean towards the special relationship being created. And then above that would be the fiduciary duty, where you're held in a position of trust and you must act with utmost good faith. Getting to the common law duty. Generally, the insurance agent does not have a duty to recommend additional or different coverage. And again, this is where these three categories that we're going to talk about here, the additional or different coverage, the recommended limits and amounts of values, and any additional or different coverage is available. That's something that I see in many of the lawsuits, whether I'm on the plaintiff side or the defense side, that come in that there was this duty to advise. And that's not really the case under the common law duty. I'll emphasize this again. The common law duty states that the insurance agent or broker has to procure the specifically requested coverage using reasonable skill, care, and diligence, or advise the insured in a timely manner of their inability to do that. And that's pretty much the low bar. That's really what it is. So when you start looking at that common law duty, the first requirement is the specifically requested coverage. What was specifically requested? And as I indicated earlier, that becomes a big problem because in many cases, the insured is not very clear on what they want. They use a lot of general terms, and this becomes part of the problem. Did you specifically ask for this? As a side, I did have a case where the insured was a restaurant and did not purchase liquor liability. They didn't have it. And, of course, a liquor liability claim came up, and even the judge, in reviewing some of the documents, said that the insured didn't specifically ask for liquor liability, and when they came to the agency, they talked in the most general of terms. The judge rendered that in a decision based on a motion that was made. And so, again, the specificity of the request can be very critical. The other problem with recommending values and everything is there's a theory that says that the insured is in the best position to know what their risk tolerance is, what they're willing to absorb in the way of a financial loss, and how much they want to transfer, which is really what insurance is about. So asking or expecting the insurance intermediary to pick those numbers and do those things is generally something that is ill-advised, unless there's an agreement between the parties and the insurance agent or broker, intermediary, accepts that responsibility. So if they say, I will come in and I will evaluate everything for you and determine all these things, then they might be opening themselves up, most likely would be opening themselves up to a problem, because if there are deficiencies, they may be held responsible for that. Okay, now, if the relationship is an arm's length, which is basically the buyer-seller type of relationship, again, it says here what I've been emphasizing, procure the specifically requested coverage. So again, there must be a specific request. If it's in generalities, it can be a big problem. And using reasonable skill, care, and diligence on the part of the insurance agent. Again, that becomes one of those what constitutes reasonable skill, care, and diligence. Interestingly enough, this is where you start to get away from the concept of being a fiduciary. This is one of the reasons why the fiduciary duty is usually not imposed. And that's because there's no obligation, in the absence of being a fiduciary, there's no obligation to get the best coverage for the insured. There's no obligation to get them the best premium. There's no legal statutory obligation. Nothing is created there unless the agent or broker or the intermediary has assumed that duty, specifically assumed it. If they say, I'm going to do the best I can, or I'll try to get you the best premium, that's a general statement. If it was an obligation they put into a document, that we're going to do this, that may have more credence to it. But basically, reasonable skill, care, and diligence is to and the operative word is to procure it. So it's not to advise the insured. It's to go through the process of getting it. And so once the insured comes in and says, this is what I want, that's pretty much what the insurance intermediary is supposed to do. And if they can't do it, advise them in a timely manner. We have a case that I'm working on right now where the insurance agent was working on a particular coverage, was having difficulty with it, indicated to the insured that she was still working on it and that she was going to, she was working on it for him. This was after a number of months. Well, a loss occurred, which was exactly where the insurance coverage that she was working on should have been. She didn't have it in place, and now she's involved in the lawsuit because the question was, why did it take you so long to get it? And if you were having difficulty, why didn't you tell the insured and say to the insured, look, I may not be able to get this for you. You need to maybe look somewhere else. Well, what she did is she says, I'm still working on it. And those last words, I'm still working on it, gave the impression to the insured that she was going to get him the coverage, and he did nothing else. And then when she didn't get the coverage and the loss occurred, he was out there naked. And had she just given him notification that you might want to look somewhere else, she could have very easily been off the hook. So she would have fit that number 2. Okay, now, under the common law duty, while there's no duty to advise, and I've emphasized that there's no duty to advise, if the agent or broker provides materially false or misleading information, then they may still be found liable. And again, that's a little bit on the tricky side because, and I want to emphasize again, that the communication terminology that's used, so an insurance intermediary may use terminology, and the way it's going to be interpreted by the insured may not have the intent of being misleading, but may by virtue of the fact that they're not necessarily talking the same language, it could be picked up incorrectly, and the end result is that the insured is misled, but not intentionally. There are situations where insurance people might actually mislead them, but again, the question would be, was there intent there? My experience is that in a lot of cases, it's not a deliberate or intentional act. In some cases, it's a knowledge-based act, that the insurance intermediary simply did not really understand all the nuances of the particular coverages that they were explaining or representing to the insured. So again, it wasn't intentional. It was a knowledge-based error. All right, on the common law duty, what I've done is I've broken down the states for you, so you'll have a record that you can reference to as to where the various states fall in terms of heightened duty or not. This first slide, and then we have a few other slides before we get to the big list. These are order taker, what I call order taker status. And these 4 states, you don't have a heightened duty. There's no duty to advise. You have that basic common law duty, period. That's all that the insurance intermediary is expected to do. Procure that specifically requested coverage using, reasonable skill, care, and diligence, or advise them in a timely fashion. That's it. There's nothing else there, and that's the 4 states that adhere to that. So basically, as an insurance person, your only obligation is take the order and move on. That's it. Now, when we talked about this earlier, that the standard of care as an independent agent or broker, it may be less than if you're an agent. If you're an agent of an insurance company as an employee, then your standard of care is going to be a lot less. So if you're working for the Geicos, it will be a lot less. If you're working for a State Farm, it may be less because you're captive to them. When you're an independent agent, you're going to be held to a much higher, not a higher common law standard, let me phrase it that way, not a higher standard, but a higher common law standard than if you're working as an employee for an insurance company. All right, now an agent may be liable for a duty owed to the insured when any of the following occur, and this is kind of reiterating what I said. The agent misrepresents the nature, extent, or scope of coverage being offered or provided. And this, again, could be one of those that's a very gray area because you're dealing with a contract, and the contract is going to be subject to interpretation. And as we indicated earlier on, the insurance company may conclude that, based on their interpretation of the contract, that the coverage was there or wasn't there or isn't there completely, whereas on the front end, the insurance agent may have made a representation based on what they thought it was going to be. And when it gets to the back end, it really wasn't that because there was some factual situation that came up that showed that the hypothetical on the front end that the agent was using and the fact pattern on the back end were completely opposite. That's one of the problems that we have in the insurance industry is that when hypotheticals are presented, they serve no purpose. It usually is to try to explain a particular coverage. The insured hears that, that's what they think, and then when the fact pattern comes on the back end in a real claim, it has nothing to do with the hypothetical at all in most cases, and you can end up with a problem in the claim. Let me get back. I skipped a slide here, and I apologize. All righty. When the agent assumes a special duty to the insured by either an express agreement or holding himself out. So now what we're moving into is going past the common law duty, and now we're moving into that special relationship or special circumstance as it's referred to in certain areas. Now this is something that is really dependent upon the actual relationship of the parties, what was said, what was done, what was agreed to. And the burden of proof on this is on the insured. So the insured is going to have to show that the actions of the agent rose to a level beyond the common law. And it's not because they trusted them. That's what we always hear in a lot of the cases. It'll be, well, I trusted them, I depended upon them, there was detrimental reliance based on the information they gave me. And in some cases, they can make the argument, but I will tell you that my experience is that the special relationship is a very high standard. It's a very high bar to make. I had a case in Jersey. I was on plaintiff's side. To me, it had every characteristic of a special relationship. And our side made a motion. We wanted the judge to render an opinion on the fact that it was a special relationship, and the judge didn't do anything. The judge just sat on it and let it go to court, and let the jury decide what they thought the relationship was. So, and the jury, by the way, found to the other side that there wasn't a special relationship, which is kind of interesting, but that was a determination. So, getting to that bar is really quite high. And you'll see when we get to the breakdown, there's different degrees of getting to that special relationship by the different states.
Ivan?
So here, yes.
I just wanted to give you a warning. We have about 3 minutes left, and we do need to get to some questions. So if you wanted to start wrapping things up, that would be great.
Okay, got it. All righty. What we're going to do next few slides are basically the states. So now you have this automatic duty to advise. Here are your states. That automatic duty to advise. Now, again, that doesn't necessarily mean they're going to be a special relationship. I indicated we had a case in Jersey. It was on that list. It didn't get the special relationship. Then we get to the other lists that we have here. 41 states, by the way, don't have different criteria to get to that special relationship, and I'm getting to the list here. Here we go. Special relationship, easy burden of proof. This next list on page 47 shows the list of these. This is where it's pretty much easy to prove. So it's getting from the common law to the special relationship. The insured has the burden, but it's not necessarily that difficult. This is where 20 states here, it's a case-by-case basis. And I will tell you, I've worked in some of these states, and it's a tough standard to get to. And then here, the burden of proof is very difficult. And for those of you who don't know, I'm in New York, and I will tell you that New York is extremely hard to try to get up to that level of special relationship. And now we get into the fiduciary duty. And I've emphasized to you that getting to the fiduciary duty status is very difficult. Most cases that I've seen, that I've reviewed, that I've worked on, it's not going to get to the fiduciary duty because, again, you're going to get into the utmost good faith, and that does become a problem. And I think I'm going to end it there so that we can get into the questions.
And to all the attendees, we will be sending out the slides tomorrow, and you can also download them from the resource list so you aren't missing out on any of the slides that weren't fully covered. So we have time for about one question. So the first question is, do the standards vary by line of insurance, such as P&C versus life or health?
Yes, it can. Yes, very much so. And actually, from an E&O standpoint, most claims actually are on the property and casualty side. On the life side, they really the claims are very insignificant in most cases. Not to say that they don't happen, but I guess there are differences. Life insurance may be more in an advisory capacity to get to the actual purchase.
And could all the attendees please type the passcode once again into the Q&A? Okay, those are all the questions that we have time for, but we will be sending over the additional questions over to Mr. Cohen to get answered later on. So in addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and forensic solutions, free interactive webinars, cybersecurity services, day-in-the-life videos, and research reports on expert witnesses, such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Ivan Cohen for his time and effort in creating this presentation. If you would like to speak with Mr. Cohen, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. Thank you all again for attending, and have a great day, everyone. This concludes our program for today.